be very happy to talk about the hearing of the Universities Canada, but there is no time, and about the grievance at McGill and all the papers that are suspended in the province.
I don't need to talk about the hearing,
Thank you.
but if you have anything to say about the order that was rendered pursuant after the hearing, the order of Justice Roussel, you have 5 more minutes to address that.
So, yes, like regarding the order, I mentioned at the beginning, like to Justice Roussel, just 1 minute, please. First, at the beginning, what happened is that I sent for them the demand letter for the members of Universities Canada, and they kept even ignoring the emails, same as the members of CMEC did. And when I sent for them the demand letter, they changed the whole website and removed the whole grounds. So I submitted the letter and I show it to the judge. When I sent the application for judicial review for the respondent, it was in the 1st of June. So the lawyer sent in 10th of June, we will respond to this application, meaning they asked for the exhibits and they asked for the affidavit. I submit them in 1st of July, then they submitted motion to strike on 17 July. And the motion to strike was according to rule 221 C that the proofs or the matter is scandalous, vexatious, like there is no proof. So when we came to the hearing, they started to discuss that if Universities Canada is included in the definition or not. So I submitted, as you see, Honor, it is, I put like the documents in the file that you have. It's at page 450. I submitted from their website that Universities Canada is established by Act of Parliament. So they started to negotiate established for what? I told them they wrote the ground to do the rules of the government and also the grounds in the website not to change it, and I proved all the grounds that they should do it. Then they started to discuss, is it a private or public act of Parliament? I mentioned to them that it is there is no distinction in the rule with whether it is a private or public. And also the judge mentioned a rule that if there is like a breach of the Constitutional Act and the human rights, the issue become from private to public. So the lawyers, he started to say to be confused like that. And also I mentioned for her that I submitted the application in June. If they feel that Universities Canada is not federal board, they should have brought the motion from that time according to the rule. I put it on it's rule 58 section 2 and rule 59. A motion under subsection 1 shall be brought as soon as practical after the moving party obtain knowledge of irregularity. They did not make objection. They told we will look at the proof. Then they brought that the proofs are vexatious. Subject to Rule 57, where a motion brought under Rule 58, the court finds the party has not complied with this rule, the court can dismiss the motion. This is the first thing. So I told her, okay, I submitted for them the affidavit and the exhibit. And if you look, Honor, at yes, at page 447, I put their motion to strike. They wanted to strike my application based that there is no proof, but they don't want that I put any exhibit or any affidavit. How come? They ask for the exhibit and the proof, and they just wanted to talk about a general issue, notice of application, and they mentioned one sentence of the agreement, good practice. Sahar discussed in her exhibit about good practice. I guarantee for the judge and the lawyer that I will break break the agreement of good practice with US and internationally just by looking at the three exhibits, Exhibit B, C, D. Nothing was mentioned in the hearing from all this. So when they say vexatious, okay, they ask for the exhibits, nothing was discussed. And they started to say it is included or not included. At the beginning of the hearing, they told we want a cost. When they saw that it is true that it can be dismissed according to all these, they stood up and they told we don't want a cost. But if you continue, we want. Because according to what was written in the grounds of Universities Canada, that any institution that break even part of the rules, the membership to Universities Canada, it will be broken. It means that McGill will not be a university. But McGill behaves like that because they know that all of that cover changing website and members will behave like this. And also the lawyers, when he stood, because he at the beginning gave to one lawyer, not expert as him, he stood, I know when they submitted in 17 days that they did not look at my exhibit. He stood and he told, Sahar does not have any exchange of email that show that there is a decision. I told him I have the exchange of email and I put it here in page 451, and he was shocked. We will check the authenticity of this. And I told him not only that, I want now to play the voice recorder. He stood and he told the judge no need for the voice recorder. The emails are enough. So then after that it is mentioned that there is no decision, not reviewable, it is not established by Act of Parliament, and all of that was discussed in the hearing.
But the court ruled against you and said that the court did not have jurisdiction over that other respondent.
Yes, yeah, and that's what
the court said that the court has no jurisdiction, even when the Council of Universities was created by an Act of Parliament. This court doesn't have jurisdiction. Here, CMEC is not even created by an Act of Parliament.
This is what the judge mentioned. The judge did not mention anything of this happened. If we will look at the rule, is it vexatious? Even the judge mentioned that it can be vexatious or something. Of course, like this decision will break the membership of McGill and will cost millions of money.
Oh, so you're saying that I shouldn't take into account, and you shouldn't take into account what the federal court has said in this other judgment.
No, but there are, this is the issue, there are judges who makes error, and when the person appeal, the judge can be referred if there is a proof. So how come it is clearly, I put for you a copy, by an Act of Parliament, how it is not included? So it means that if we want to include an organization in the definition, we will include it, and if it is not, how the other cases are, like when there is a breach of all the rules, there is no control of them, the federal court has took many of cases like that. And the structure of CMEC, it is included in the federal. They put external partners starting from 2003, and it is across jurisdictional. Nobody will give fund unless like the responsibility is shared.
Okay. Now, the applicant is seeking its costs on the motion. Can I have your representations as to where costs should be awarded, whether and in what amount?
What amount I am not familiar, Honor, but I request the cost and cost for damage. Even if they awarded the cost, they will pay it later in somewhere else. For all of they will take responsibility.
And you have nothing to say about the bill of cost that was submitted by the respondent?
I have objection to pay anything.
Okay.
They are responsible. And if now they are dealing with me tomorrow, because I know what is there and what is policy, they will deal with a lot of people who were dismissed in the past and in the future.
Thank you. We'll go going to adjourn for 5 minutes. My decision on the respondent's motion to strike the applicant's application for judicial review without leave to amend and with costs. I've considered the parties' respective motion materials and heard the parties' oral representations. Considering that the federal court is a court of statutory jurisdiction, but can have no jurisdiction unless there is both a statutory grant of jurisdiction and constitutional jurisdiction. And I refer here to the Supreme Court case of ITO, International Terminal Operators versus MIDA Electronics. The reference is in the respondent's motion record. Considering that the statutory grant of jurisdiction to this court in judicial review is conferred by Section 18 of the Federal Courts Act and is limited to federal boards, commissions, or other tribunals as they are defined in Section 2 of the Federal Courts Act. Considering that Section 2 of the Federal Courts Act limits the definition of a, quote, federal board, commission, or other tribunal, end quotes, to those bodies having, exercising, or purporting to exercise jurisdiction or powers conferred, and that's where it's important, by or under an act of Parliament, or by or under an order made pursuant to a prerogative of the Crown. Considering that the applicant could identify no act of Parliament or prerogative order of the Crown pursuant to which either the Council of Ministers of Education in Canada, CMEC, or its chair purport to act. Considering that neither the receipt of funding by the federal government nor any consultation or interaction between CMEC and federal ministers or departments can, at law, stand as a substitute for an act of Parliament or a prerogative order of the Crown as the source of the jurisdiction or the powers contemplated in Section 2 of the Federal Courts Act, and on which this court's jurisdiction in judicial review can be founded. Considering that it's plain and obvious that this court has no jurisdiction in judicial review over CMEC or its chair, and considering that the court's clear lack of jurisdiction is sufficient to justify striking this application, considering that it is not necessary to determine, and that the court does not determine any matter pertaining to the merits of the applicant's complaint or the availability of any remedy sought. Considering that the respondent should have its cost of the motion, but that the volume of the materials submitted was unnecessarily large, such that disbursements relating to reproduction should be reduced, the court orders that the application be, and it is hereby struck without leave to amend. Costs in the amount of $1,500 shall be paid by the applicant to the respondent.